To order the Zoning Board of Appeals meeting for Tuesday, July 12th, 2022. Just a quick point here before we begin. To the applicant, today we do not have our full complement of the board present. So, yes, we have our fifth person here, but you need to be aware that if you were to request that this be postponed to the next meeting in next month, you can do so. Of course, you would have to put it in writing, besides stating here on the record today, but that is an option that you need to be aware of, because as it stands today here, you would have to have a minimum of 4 of us voting in the affirmative to override the administrator's decision. So I just present that to you as information and let you make your decision. Okay? Thank you. All right, so we're going to proceed then here through the rest of our agenda and the administrative content of it. All right, Crystal, if you will please note the attendance, ma'am.
Board Member Delaware?
Here.
Board Member Hanner?
Here.
Board Member Lindsay will not be here. Board Member Jones?
Here.
Board Member Moreno?
Here.
And Board Member Rogers?
Here.
All right then. And I do not believe there's any additions or deletions to our agenda, correct?
Yes.
Thank you. All right, we have no unfinished business that I'm aware of.
No unfinished business.
Beautiful, which brings us down to our current new business. And the process that we'll employ here today is I will basically open the public hearing, at which point I will be asking for a staff report, which basically we should all have copies of already here. And from there, we will then proceed to have the applicant come up. Please come to the microphone, state your name, your address, for the record, please. And each and every time that you come back and forth to that microphone, please remember, name, address for the record. At which time, once you've kind of given us your details, things that aren't already covered here in the staff report, we'll then move to the next phase of it, which is to ask questions. The board will ask questions, if there are any, of the applicant, of staff as well. And at which point, once we conclude that part, we'll then move to the comments for those that are here, for or against, if there's anybody that will be part of the public that will be asked, to come up, give their name, their address for the record as well. And once we've concluded with all of that conversation, we'll then close the public hearing, and then the conversation will shift here to the board, where we will have our discussion, after which a motion will be made to either A, affirm, or to deny, one of the two. All right, having discussed all that administrative activity, I'm going to turn over here and ask staff to please give us staff report.
Thank you, Chair. Before I begin, I just wanted to let you know that Mr. Jonathan Baber from the City Attorney's Office will be attending via Zoom, or be available via Zoom to respond to any of the board's questions, as his name was brought up in regards to a phone conversation in the applicant's appeal. Okay, staff report. EGC Processing is appealing the zoning administrator's decision to deny a request from the applicant to build an addition onto their existing marijuana processing facility at 4661 Dickman, Suite A. This is an appeal of the zoning administrator's decision. In other words, did the zoning administrator correctly interpret the current zoning ordinance? The applicant has not applied for a dimensional variance. The subject site is zoned I2, or heavy industrial, which currently allows medical and adult use marijuana processing as long as the processing facility meets the requirements of Section 1251.28 of the City of Battle Creek's zoning ordinance. The current zoning ordinance states that a medical and adult marijuana processing facility must be 1,000 feet away from any residentially or R-zoned properties. This is measured property line to property line, according to the zoning ordinance. On 5/17/22, The Building Permits Division received building plans for a building addition to their existing building at 4661 Dickman Suite A. The zoning administrator reviewed the zoning ordinance requirements, which allows marijuana processing in the I-2, but requires a 1,000-foot buffer from residentially zoned R properties, and found that the distance between the RM1 zoned properties and 4661 Dickman was less than 1,000 feet as measured property line to property line. And there is a map that was emailed first with the staff report that shows one of those lines, but I also requested that our GIS department develop a clearer map and also double check my distance measurements, which they did. So you should have received that in the last couple of days. And I'd like to make that as an attachment to this report as well. So the distance between the RM1 zone properties and 4661 Dickman was less than 1,000 feet as measured property line to property line. The existing marijuana processing facility at Suite A is being considered legally non-conforming according to the current ordinance. Consequently, once I found that, zoning administrator then reviewed the non-conforming section of our zoning ordinance and found that legal non-conforming buildings for a use other than residential and that are not required to expand are not allowed to expand their height, area, or bulk. Therefore, the zoning administrator denied the request for the addition to their existing processing facility. 2 court cases were cited in the applicant's appeal. Okay. The first, which is Grand Haven versus Brummel, the Michigan Supreme Court ultimately allowed the builder to complete the construction of the second building. We're considering this different from the situation with EGC's appeal. For one, the city allowed Evolution, EGC doing business as Evolution, to complete its build-out as already approved. In addition, EGC did not notify the building department of its intent to expand or anything at least that we can find. So the proposed building addition expectation was never expressed or approved. Due to the differences in the facts of Grand Haven versus Brummel from our situation with Evolution, we don't believe this case is helpful. The second case, Pittsfield versus Malcolm, the building inspector mistakenly issued a permit for the building of a dog kennel. The township learned of the mistake and took action to stop the operation, and the court found in favor of the kennel and allowed it to continue. However, applying this to EGC, we have not nor will seek an injunction to prevent them from operating in violation of our setback ordinance. We're considering them non-conforming. And Pittsfield versus Malcolm also does not address allowing expansion of the non-conforming use, which is the subject of this appeal. The history and the timelines in the report are really provided for reference only. The history and timeline is really not relevant to this appeal, as this is just an appeal from the zoning administrator's determination of what's in the current zoning ordinance, and that the property does not meet the 1,000-foot buffer setback from residential, and is currently non-conforming, and according to the City of Battle Creek zoning ordinance, section 1270 nonconformities cannot currently be expanded. This appeal before you is just asking to reverse the zoning administrator's decision regarding the above. And I would also like to, again, add that the building plans the applicant provided, which were mailed separately to you, because we redacted some of the information because it might have been pertain to security or something like that. We usually look very carefully at the electrical plans, for example, was redacted and then mailed separately. I'd like to make that, as well as the map that the GIS department created, both attachments to this staff report. Thank you.
Thank you. All right then. So the applicant, if you want to come forth and give your name and address for the record, and if there's anything additional that hasn't already been presented in staff report, if you want to present that, please.
Thank you very much. My name is Will Furtado. I'm an attorney with Aronoff Law in Royal Oak. We represent Evolution Cannabis. I'm here today. Craig Flocken, Dave Madsen, Matt Lavender, Brooke Lavender, basically the leadership team from Evolution, because this is a very important and serious issue for Evolution's development going forward. As Ms. Cronander has accurately put forward, we're appealing the zoning administrator's denial of a building permit to add an approximately 2,400 square foot space to the property that is currently existing at 4661 West Dickman. That property has operated as a fully authorized, licensed, permitted cannabis processing facility since January 2021. It has gone through 4 separate approvals with the city of Battle Creek regarding its location, the facility, what it does. And each time those applications have been granted. Until May, when they applied for a simple building permit to build out an expansion space that would hold raw materials for their edibles line. So gelatin, sugar, flavorings, not cannabis extract, not marijuana flower, nothing like that. And they were very surprised when they got this letter back from the zoning administrator that said they are in violation of the 1,000-foot setback. Never before had that been mentioned, been raised, been discussed, or been noted with Evolution in the dozens of meetings that it's had with the city of Battle Creek. Again, the 4 application processes and renewals it's been through. The state of Michigan did not make a note of any violation. So at this point, we put together a statement of appeal because we believe that the denial of that building permit is inaccurate. We believe that the building is operating in accordance with the ordinance as the city of Battle Creek has enforced it and applied it over the past 2 years. And we're seeking the Zoning Board of Appeals to reverse the zoning administrator's decision, pardon me, and grant that building permit going forward. This is a situation that represents millions of dollars of investment for Evolution Cannabis. Tens of thousands of dollars in building, application, and permit fees paid to the city of Battle Creek, and a years-long effort to develop a world-class cannabis processing facility in Battle Creek. And this risks all of it. We've prepared some materials for the board, some aerials that show the property. They're very similar to the satellite photo that Ms. Cronander introduced. But what's very clear from this is that this property, 4661 West Dickman, has always been approved, and that the property that now creates the problem, we'll call it the offending property, which is located in Springfield Township, has been there, has always been there, and has not changed, but is now becoming a problem. Interestingly is today, Evolution, I have a copy for the board, got a letter from the city of Springfield regarding that property and their placement of a cannabis facility at 4661 West Dickman. Springfield Township has no problem with the location of their facility. It would not violate their ordinance. The residential location located in the city of Springfield would not be a problem. I know the Zoning Board of Appeals takes these matters very seriously. I know Susan Cronander does her job well and does it seriously, and she does it in a way that she tries to uphold the ordinance. But what is clear from the history here is that the way the ordinance has been written on its face is not how the ordinance has been applied for 2 years. And to now deny my client this permit on a new interpretation of the ordinance, on this supposition that they're acting under a non-conforming variance, has no support. And so we've come today to ask the Zoning Board of Appeals for relief to grant this permit and allow Evolution to continue to be a productive, paying, contributing commercial partner in this community. Do you have any questions for me?
I don't have a question. Members of the board?
I don't have any questions to the petitioner. I might have some questions for the city when it's appropriate to do so.
It's time if you have a question for staff, if you want to ask it now.
So, a couple quick questions, and this is probably more to bring me up to speed. The property is being classified by the city as legal non-conforming. I think that stems from the marijuana ordinance and the 1,000-foot setback. Is that correct? So the city provided permits for them to operate despite the 1,000-foot setback, but when the permit was issued, they said, okay, the permit is allowed, they can operate, but it is in violation of the 1,000-foot setback, thusly it's legal non-conforming. Do I have that correct?
And in this case, to be honest, I don't know that that's the case. I mean, in the history of it, like when the ordinance was changed versus when the improvements were made, et cetera. The fact is that it was approved. They put money into it. Court cases have determined that once you get to a certain point like that, it should be considered legal, non-conforming, and they're allowed to remain. So that's how we're treating it, regardless of what the history has been. I've been here for 10 months, and all I can tell you is that when I received the application for a building addition, I did what I normally do, which is look at the ordinance. I saw that the use was allowed, looked at the buffer requirements, saw that it was not allowed because it was within 1,000 feet of the other one, or I'm sorry, of the residential zoning, because it does say R zoning specifically, so I checked that as well. And so at that point, I had to operate kind of based on the fact that it was non-conforming. I mean, there's not much, it's already operating. However, the zoning ordinance clearly was showing to me that an expansion was not allowed. When I look at the non-conforming section, after I looked at the fact that it didn't meet the buffer, non-conformities, residential is allowed, some expansion. By law, for some reason, something is required to expand. Obviously, it's allowed some expansion. But we're talking about the height, bulk, and area of a use, expanding that once it's non-conforming and not residential is not allowed. So my determination was based solely on that, and their appeal is solely based on reversing that.
Understood. Is
Okay.
there anyone at the city who can speak to the series of events behind the facility being licensed and at the same time falling into legal non-conforming?
Commissioner Rogers,
Please.
Marcel Stutzel, Deputy City Attorney. Deputy City Attorney Jonathan Baber is available by conference call or video conferencing. He can probably provide you that background that you're looking for. I would help to answer your question, though. It's not isolated to just the marijuana ordinance. There were events that occurred before and after the zoning ordinance was amended. Many things happened before, many things happened. And when you look at the process, the zoning ordinance amendments added some new requirements, and at that time, it created a situation where the property became legal non-conforming. Not until May of this year did that become a question. Other work, other permits, etc., was all interior to the building and did not touch upon the fact that there was a potential zoning code issue. So let's see if you want to direct your questions to Mr. Baber. He may be able to more fully expound upon that.
I have a question relating to this. So, I guess, does the city in its files keep notes on different pieces of property and so I noticed here that the facility for medical marijuana processing probably was completed in January and they opened in January. And then later, they added an additional permit, if I'm understanding the timeline correct. And then my other question to this is, was the 1,000-foot setback in the changes in April of 2021 to the zoning ordinance? When was the 1,000-foot setback in?
And to be honest, offhand, I don't know the answer to that question. Even if it was originally an error, which I don't know that it was, when the marijuana was approved, and then stacked with the adult use later on. Even if that was the case, this is still legally non-conforming because of all the money and everything that they put into it. We're considering it that way. However, that does not mean that they can continue to expand a non-conforming use. That's
Sorry,
what my
I can't see that.
determination is, and that's what the zoning ordinance says.
I'm sorry, this is too small for me to see.
That should be in your packet.
May I
So, Mark,
It's on page 6
it's
of-
in your report.
Oh, yeah. page-
Right, is that the timeline? Okay, that's what I'm
Yeah,
reading from. I'm
yes.
reading on my page from the timeline.
Yes.
But that to me is very key to this case is when was that law adopted? Or when was that part of the regulation adopted?
So the zoning ordinance was amended in April of 2021.
Correct, but was the 1,000-foot setback in that amendment, or was it in the original law?
Mr. Jones, are you saying the original law before the zoning code was amended in 2020?
No, in the 2020, what I'm really asking is, did the rules change on them in the middle of the game?
Yes.
I mean-
That's how they became legal non-conforming.
But in specific, was that 1,000-foot rule changed in the middle of this process?
Yes.
So you're saying that 1,000-foot rule was added in April?
It was either, I don't believe it was April, I believe it was December. I don't have the April amendment in front of me, but my recollection of that, the amendments to the,
Because the entire code was redone and adopted in December of 2020, yeah.
Well, I'm going to...
zoning code had a major rewrite that went into effect December of 2020. There were some minor amendments in April of 2021. I don't believe the minor amendments included the 1,000-foot setback. But even if they did, the effect of a change to the zoning code under the Michigan Zoning Enabling Act, under the City of Battle Creek ordinances, anything that is existing at the time that becomes non-conforming is allowed to continue.
No, I understand that.
That is the proper interpretation of the law, and that was the proper application here.
I'm going to pin my further questions until we get to commissioners' comments.
I was wondering if I could make a comment.
Are we letting Jonathan speak?
One moment.
Thank you.
I'm trying to get them all. Is it coming out?
So, Commissioner Rogers, you have,
Yeah, and pardon me, and I don't mean to beat a dead horse, but let me restate the question to make sure that we're all on the same page. The petitioner applied for a license. The petitioner was granted the license. At the time the license was granted, they were completely conforming. The law changed. The change in the law made them effectively non-conforming, so moving after the change in the law, which happened after the granting of the license, is what caused them to become non-conforming. Am I seeing that correctly?
That part is correct.
Okay.
Yes, sir. And that is why there is a process in the zoning ordinance for addressing nonconformities.
How can you...
Ordinance includes nonconformity provisions, and it includes that this body can receive appeals dealing with dimensional variances. When a nonconformity exists, and it's a distance nonconformity, or it's a size or a height or an area, the proper place to bring that request would be to this body.
And I'm going to assume that when the new ordinance was passed, there was probably some posting and publications. There was probably a public comment section when the new ordinance was passed.
Correct,
I'm
that's
assuming
required
there are
by
some
law.
procedures that-
Yes,
Okay.
yes. It was also advertised, I believe, on the local, in local media, on the news. A lot of it was done with public participation, so yes, there was a lot of notice.
Commissioner Davis and Commissioner Jones, if I can ask Mr. Baber, he might be able to clarify
Okay.
as to what happened in April, if we can get him brought in.
Yeah, where is he?
Maybe a zoom on your screen over here,
I'm here if you can
In
hear
the
me.
ether?
the top right screen.
He was not able to be in.
Or the one in front of us. He's zooming.
All right.
Mr. Baber, can you hear me?
Yes, I can hear you from you.
Have you heard the questions of Commissioner Jones and Commissioner Davis regarding what happened in April of 2021 with the amendments to the marijuana ordinance?
I have heard the questions. Unfortunately, I don't have anything in front of me to state with any certainty as far as what happened in April 2021. I do believe that all of the amendments in regard to setback requirements would have happened in 2020 December, but I'm just going recollection similar to you, Mr. Stoffel. But it would be also my opinion that the worst case scenario of this would be the mistaken approval of building permits even from the beginning. So there would have been a mutual mistake on behalf of 4661 Dickman and the city. Even in that scenario, it would still end up being a legal non-conforming use based on the case law, and we'd still be right back where we are having this discussion.
I would ask the gentleman on Zoom a quick question. So we've got two scenarios. One, the license was granted in error because the current 1,000-foot setback was in place. Or two, the license was granted correctly and then was basically forced into legal non-conforming when the 1,000 was added. In your opinion, do you feel that the petitioner's cited court cases might apply more correctly if the original license was granted in error?
In fact, one of the cases cited was that particular situation where there was a building permit issued in error, and it was a mutual mistake on behalf of the city and also on behalf of the applicant. The Supreme Court ultimately allowed the builder to finish building out the two homes that they were building based upon a mutual mistake of approving a building permit. Ultimately, what that does not address is the furtherance or the expansion once the mistake has been discovered. So that case really is in line with what we have going on here, because it would be a better case if the builder wanted to build a third home in addition to the two, which is what's happening here, because ultimately 4661 Dickman, even if there was a mistake in approval, has finished that build out, and now we're here today knowing that they're in violation of the setback and making that determination as far as whether the city must grant the building permit, knowing that it's in violation. So it's a different scenario than both cases cited by the applicant.
Thank you for your answer to that. I appreciate it.
All right, then, I believe you had a comment you wanted to add.
Thank you. Will Furtado again on behalf of Evolution. We have a couple pictures here, and with respect to the change, any alleged change in the application, or in the ordinance, I apologize. This is a blow-up. This is a blow-up of the current map that is on the Battle Creek website regarding processor locations. This small white parcel in the middle right there, surrounded by green, is my client's parcel. That is somehow non-conforming and received green when and other properties that are approved are abutting this residential property. We've discussed this in the statement of appeal. So to the extent there was an ordinance in place and our client is non-conforming, this ordinance is not being applied equally to the parcels. It's being applied one way to our client and another way to other parcels. That is a problem. That's a due process violation. It's a substantive rights and procedural rights problem. There are millions of dollars invested in this project on approvals that have been granted. And when we're talking about non-compliance and non-conformity and continuing to operate under non-conformity, what we're talking about is a variance. The city is saying, you've been operating under a variance, a secret variance that we've never mentioned to you, we've never noticed before. We've allowed other building permits to occur, change of use building permits for your property that was granted in, I think, November of 2021, actually changing the use of a portion of the interior space. No problem with those permits. We've even talked with the city about trying to expand the basement space of this building because we're so limited. And the city has told Evolution, no, that would be an expansion of your non-conforming use. Something we've never had notice of before now.
I have a question regarding this. You said this came from the city's website. Did it come from the city's website or Battle Creek Unlimited?
City of Battle Creek Zoning Board of Appeals website. This is the map that has the processor. So you can go to the City of Battle Creek website.
Okay.
Yes, it's,
So are you saying that there are medical marijuana manufacturing facilities closer to these residential areas?
I do not know. I know that the city is representing that these spaces that are close to this residential area are green zone spaces for cannabis businesses, as recently as this month. Pardon me?
Susan, you can just.
Yeah,
Folks.
you can find them on the website.
Sidebars have to come forward, please.
Who we have here, by the way, I mentioned with Paul Talinda and Ron DeSico, who is the property owner and his attorney. He's here, Ron's here to represent himself as the owner of this property. He has a significant investment. He has another tenant that's a cannabis operator. He wants to be able to use this space. He bought it for the purpose of using it as a cannabis facility. These are,
So did I just hear you correctly in saying that there are two tenants in this building
yes,
and both of them are cannabis operators?
yes.
Do you have a variance for either of them?
We've never seen a variance of anything.
When did your other operation begin? Please come forward.
and Chair, if I may, when you have a chance, I'd like to speak to the map.
All right.
Thank you.
My name is Ron DeSico, address 444 Chalfont, Grosse Pointe Farms, Michigan. I am the managing member or owner of the 4661 West Dickman property. There is two tenants. This is one. The other has applied for and received building permits to build out a medical grow. He is a clinical pharmacologist interested in research. His background is in chemistry, as is mine, which is why I got into this, because I've been in home care and hospital-based home care and hospice for 30 years. I do have a prepared statement, which I can read when the time is appropriate. But
We'll wait for that. But to your question, so is your other tenant currently operating?
he is in the process of the build-out. I know we've spent about $1.6 million from what
Okay.
he doesn't even know this is happening. I never got notice of any changes of anything. I get my tax bills, I get my utility bills, I pay everything. I never got notice of a change of any kind of zoning or nonconformity or anything of the sort.
So have you received building permits for that build-out?
It's not mine, it's his. Yes, he has.
He
My
has
understanding is
received-
he's gotten, I can't say I haven't seen them personally,
Right.
but I know that he's had a number of inspections. I know there's been building process going on for some time.
Okay,
So-
Okay.
a moment.
Okay, just if I may, in respect to the build-out, that is not a building addition. That's interior, for which he received a marijuana license, I'm assuming sometime in the past. So that's not a building addition, just to clarify. Secondly, that map is from the city's website, correctly, and it shows eligible properties. That does not mean that at some point they may not meet the buffering requirements that are in the zoning ordinance. There's a list of 5 things that they need to be 1,000 feet from. Sometimes that changes. So that is probably most of the properties that are zoned industrial in that area, for which these uses, like processing, are allowed uses. But then they have to meet additional qualifications. Some uses, and it's not just marijuana, there are other uses in the city that sometimes have to meet additional qualifications in order to be placed in that location.
Thank you.
I would like to offer the board the letter from the city of Springfield submitted to the record.
All right, if you will, hand it over here to staff. And that just is an indication that Springfield as a city doesn't have a concern with this particular,
It says that city of Springfield has reviewed the property at 4661 West Dickman and does not see a violation with its setback rule.
okay, but that is the city of Springfield. Thank you.
So are we near a city of the Springfield property line here? That was something that he touched on, but
The green line, at the edge of the green is Springfield.
So this, if.
the edge of the green, so I mean, his property is surrounded by Springfield, is that what you're saying?
No, the green is Battle Creek, Fort Custer.
Okay.
White is City of Springfield.
I got you, okay.
Right, that's where the R1 or the R
Okay.
facility exists.
Images from the building, looking out across West Dickman and looking towards the property. As you can tell, your view is of a Marathon gas station, two-story commercial building. You know, the property that is at issue is back here behind this Marathon. And we have, just to give you some scale, this is also in the Scrimmagers, but this is my client's building, Crimmers Edition is right here. I'm showing this floor plan. Sorry. And the property that is creating the problem here, as we understand it, are these residences and this parcel right there. So we're talking about a property that has been there, has not changed, has been used continuously as a marijuana processing facility, and now is being told that conditions have changed, your use has changed, and you're limited because you're non-conforming. We don't think this is fair. We don't think it's equitable. And Evolution is prepared to proceed further if its permit isn't granted and it can't exercise its commercial rights with that property.
Thank you. All right. Did any of the commissioners have a question or?
I have a few questions on here.
Please.
The residential property we're seeing there, to me, those rooftops look like they are multifamily units, is that correct?
That is what the zoning is for that property.
They are
It's
multi.
RM multiple family.
It's an apartment complex.
Yeah, I haven't actually verified exactly what they are on the ground,
apartment.
And they
but
appear to be attached, is that, so there's more than 5 units?
Yes.
yes,
Because in appraisal world, that's commercial. It's not residential. It's a commercial, I mean, it's your residential use, but anything over 5 units in the world of appraisals for property is commercial.
That's relevant to lending, though.
Yeah, relevant to lending, so,
Zoning,
right. But it's zoned, the zoning code says it's residential, okay.
yes, the zoning code, yes, and it's R specifically,
Yeah.
so.
And then the other thing I wanted to point out to Commissioner Jones and Rogers is that the last sheet with the tax record shows the timeline. You can see the enforcement codes. It gives you some kind of a date sequence on the timeline of when some of the permits, and it does appear they applied before the ordinance changed. Based on, if we look at the oldest permit they applied for was in November, and if the ordinance officially changed with a vote in December, then their application would have been already approved and they would just become non-conforming. Is that correct understanding of that?
Yeah, during the Part A and Part B of marijuana applications, they are allowed to get, they're actually encouraged during Part A to pursue site plan approval and building permit approval, and then during Part B, start the build-out, so, or I should say interior renovations.
So when I look at the timeline of enforcements, when you see that timeline, there's some that were closed out. I don't know what the acronym for MMF, I'm assuming that's medical marijuana.
Yes, medical marijuana facility.
There was a closeout in November of 2021. And when was the new changes, the ordinance were voted on December, when did it take effect?
It was voted on in November of 2021 and went into effect December
In December.
11th, I believe.
So they would have been, their application would have been in process already?
Well along, yes, because they then, for their medical, received the approval, I believe it was at the beginning of February,
Okay.
so.
Yeah, and I see the final closeout looks like it was somewhere in June.
That was for the adult,
Okay.
layered on top of the medical, correct.
And if I may, that was just one point. There's two different applications that have gone on here. There's been the medical that started in the fall of 2020 and was approved in early 2021. And there was an adult use, which is a separate license, separate permit from the city. That is in summer of 2021, after all of these ordinances were in effect, the 1,000-foot setback was in effect, and that license was granted. That permit application was granted without any notice that there was going to be any sort of restriction, that it was non-conforming, that they were continuing or allowing that based on the medical marijuana non-conformity. None of that was ever provided.
Well, if your application was started under the old ordinance, they wouldn't change it to the new ordinance on the same property, would?
Two different forms of marijuana use,
Right.
Mr. Delaware.
Okay.
One began, it was still the same type of use, a marijuana use.
Okay.
But separate licenses through separate application processes, separate application processes and separate approvals from the city.
No, I understand, but what the city's maintaining is the ordinance was changed somewhere either after you started the application process and they didn't like pull the rug out from under you and cancel your facility.
With respect-
They allowed it to be established.
With respect to the medical marijuana facility application, that may be the case. With respect to the AU application, the adult use, nothing was changed during its application process. It was applied for after any sort of ordinance change occurred.
Then why do I see an adult use renewal on November 15th, 2021?
Because that's 2021. They renew it the calendar year. They don't renew.
No, I understand, but the ordinance changed and it went in effect in December of 2021, so your application.
No, the ordinance change went into effect in
2020.
2020? Okay,
Yes.
I'm sorry. That's where I was missing.
So are there any other questions here from the commissioners or the applicant?
No.
No.
And just to continue that note, though, those renewals, both the AU and the medical, were made in December of 2021. So that was another time we went through the city process, just to make that clear. On the schematic, you can tell that the addition is going to be built out on the west side of the property, which is where the actual working entrance to the property is, not on the Dickman side. It's going to be built out further away from the residential property. I don't think there's anything else.
All right. So what I'd like to do now is there anybody else here to speak for this particular request?
Just real quick, I think it's kind of lost in the map, but I don't think you
Please
realize.
identify
Sir, if you
yourself.
will.
Sorry, name Ron DeSico, 444 Chalfont, Grosse
Thank
Pointe
you.
Farms, Michigan, 48236. I think what could be lost on this map is the actual size of this property. This is huge. If you go property line to property line, as opposed to building corner to building corner, it might have a different outcome. But let me just state here, historically, the city of Battle Creek decided to participate in the cannabis industry as a revenue and community enhancement endeavor. This was obviously done to increase tax revenue, property values, increase jobs, and increase safety. In committing to this objective, I'm sure the city held numerous meetings and sought community participation in the form of feedback. As a result of weighing all the positives and negatives, the city management continued to move forward. At such time, the administration developed zoning requirements to be memorialized in green zones where cannabis-related endeavors would be allowed to operate. At such times, the green zones were widely published. Relying on green zones as well as numerous conversations with city officials, I identified a property listed in the green zone that met my requirements. The location, 4661 West Dickman, or the Robbins Building, having been largely vacant with individual suites unoccupied for anywhere from 2 to 10 years. As such, the city was receiving no tax revenue. The city was responsible for paying all maintenance and utilities costs, including gas, electric, upkeep. costing the city thousands of dollars per year. Additionally, the building roof was way past expected life, and it created a leak in the lower level, which had some profound negative effects for the city. I won't go into detail about that. As far as my background, I've been in the home care and hospital-based home care and hospice business for 30 years, realizing the need for alternative treatment and therapies, as well as my undergraduate degree in chemistry, and the need for more effective forms of treatment, I decided to become part of the industry. The property in question was listed for sale in the green zone by Battle Creek. I signed a purchase agreement and moved forward with the acquisition. During my due diligence, I discovered that the property was not licensable for all 5 separate licenses, which was represented to me by the city. We discovered the 5th license, retail cannabis, was in violation of one of the setbacks. However, I decided to move forward because my interest was in processing, growing, and refining the product, which I was assured all 4 were acceptable. Purchase was made on 2/11/2020, and we moved forward with plans for processing and growing, along with EGC processing and precision, or Presley Precision. They are similarly situated in the interest of the industry, and joint venture of sorts were discussed. A lease was entered into with the group, and they moved forward. Starting thereafter, a second group, who is a clinical pharmacologist, chemist, and has brought several drugs to market, has also occupied space for the development of extracts to aid in the application of drugs to patent for the treatment of various disease states. Now comes a letter from zoning department stating that additional expansion requested by EGC and Presley Labs is not complying with zoning, when we know we have been given the blessing by the city on a number of times. I would not have purchased the building had I not been assured it was zoned correctly, which I believe it is. The setbacks noted do not apply, as it is a separate jurisdiction, and the city's zoning should not and does not extend beyond its boundaries. If it did, what would be the point of having any zoning regulations whatsoever? Again, we're back to the Springfield issue. I am appealing to your sense of fairness and equity and approve the request. This adds additional revenue to the city as well as jobs, improves property values. In addition, the city could potentially lose hundreds of thousands of dollars in the form of taxes and other licensing fees made available through the state program. Thank you.
Thank you, sir. Is there anybody else here in the audience wishing to speak in favor of this matter?
Good afternoon. My name is Paul Talend. I'm an attorney. My address is 18720 Mack Avenue, Suite 270, Grosse Pointe Farms, Michigan 48236. I'm the attorney for the building owner, 4661 Dickman. I wanted to kind of draw some attention. I did find in the city's code that the ordinance that we're dealing with here having to do with setbacks, the first one was Ordinance 10/2020 that was passed 11/24 of 20. It was also amended with Ordinance 4/2021, which was passed 4/13 of 2021. So we have some notice requirements, and you've got the timeline that you can match it up as to when those applicants applied, what notices they were given, and how the measurements were taken. The part that I want to make sure is really drawn attention to is the fact that we are considering a residential area in another jurisdiction. I believe the line you can see this. I believe Springfield starts here, and this is where we're considering. Just for the record, I'm pointing across township lines into Springfield Township, and the general principle of, and I've seen, I think the board has seen this more than once, is that you can't tell your neighbor what to do with his property. Your neighbor can't tell you not to hang your hammock. You can't tell your neighbor not to have a dog. So the basis of it, and it's contained within the Zoning Enabling Act, is that the power that the city has when it creates zoning pertains to its own zones. And that is to say that the power that I have pertaining to my property ends at my property line. And that if I have an allergy to dogs, my allergy to dogs doesn't restrict my neighbor from owning one. If I have an allergy to pine, my allergies does not restrict my neighbor from planting pine trees on their property. That's the beauty of separate sovereignty. And that's where the consideration comes in to say that when you are considering that your zoning says you cannot be within 1,000 feet of any residential, your term "any" is limited to your authority, which is the city of Battle Creek. That's one of the most important parts about this has to do with the acknowledgement of the legislative power of the ordinance and the regulating power of the ordinance itself. Now, in the same way is, and this I haven't seen or heard, is that if there were an overruling state statute that said marijuana or anything Schedule I has to be 1,000 feet away from a residential use, then your body can defer to the state statute and proceed that way. But when you are confined here within your own ordinance and your own legislation, you must consider that. And you can't go into what my neighbors are doing in their backyard, because in the same way, you don't want them considering that necessary of their creation. But that's really the overarching issue here, is that when you get into, well, let's just say when you get outside of your own boundaries, it further creates complications, and that may be where a lot of this decision-making was had, is that to say, we didn't look to Springfield and their use, and we never did until now. And that might be where the improper decision-making lies. I appreciate the time.
Thank you. Is there anybody else here to speak for this particular matter? Anybody else here to speak for this particular matter? All right then, is there anybody here to speak against this particular matter? Anybody here to speak against this particular matter? All right then. There are no public comments for or against. So let us then move to close this public hearing, and we will now turn it over to our internal discussion.
I move to grant the appeal of the applicants.
Is there a second?
If we don't put it on the floor, we can't discuss it.
That's true, Mark. That's why I'm asking, is there a second?
Support.
All right, it's been moved and supported. And the motion that made is to grant the rescission of the zoning administrator's decision. That's what is on the table right now for discussion.
I'd like to ask the city attorney a question.
Please.
Can you, and regarding the gentleman's about the property lines of the state, the municipalities, we've encountered this before with the city of Emmett Township.
With Emmett Township.
Could we read the language of the 1,000-foot setback in our ordinance? And
Pardon? I
we
missed
see the
first part.
language of our 1,000-foot setback in the ordinance.
Do I see that?
Is it right here? Is this the?
Yes.
That's the exact line, okay.
Yes.
If
And
I
as-
recall in reading this, Mike, it does say residential.
Yeah.
I understand the petitioner's argument. My concern is that this body does not have power of legislative review. I don't know that it's within our power to say this law is not written in conformity with the series of laws that exist. Thusly, we grant it based on our rejection of the city's writing of the law. I have a concern with that. He may have, the petitioner may have, be able to make that case within a court of law. I don't know that we have that power.
Yeah, that's what we ran into when we encountered this before with the Emmett Township line. I just wanted to.
The essence of that is, you are correct. We don't have the ability to tell our neighbor what to do with their property, but what they do can affect us, and we've already ruled twice in cases regarding this. So, to your example of allergies, I can't prohibit my neighbor from having a dog because I have an allergy, but I can set a rule to myself that I have to be 1,000 feet away from a dog for my allergies. And that, in a sense, is what we have done. And we have upheld that at least twice. regarding our neighbors. And yes, we sometimes have uncooperative neighbors.
Any other board comments here in discussion?
Just, if I could, real quick.
Please.
I have a lot of sympathy for the petitioner. I think that when we get into interpretation of the strict letter of the ordinance, the city puts forth certain notices. We could have a very spirited discussion as to whether those notices are adequate to inform the citizenship of what changes in ordinances are, but generally speaking, those notices are seen as legally acceptable postings within local publications, posting on notice boards within the city. Again, I have a certain amount of sympathy for the petitioner, but when the law, the new ordinance was adopted, it was posted presumably, no one has told me differently, in the correct manners, thusly notice went out. In theory, based on the law, that information was then put out, for all citizens. It's theoretically should be known, and my inclination is to reject the petitioner's request.
Thank you, sir.
To your point, yes, I myself have experienced that. I bought a very old home, and, in the time that I bought it, the city changed an ordinance, and that affected me. So I very much understand that. And I missed that public meeting. It very much upset me, but I missed the public meeting, and therefore, I wasn't paying attention. But my concern is, it kind of goes back to a very famous quote of what did the president know and when did he know it? And in this case, I really have a very strong concern about the nonconformity decision, because I went back and reviewed our records. We didn't issue any variances to this property in 20 or 21. Matter of fact, we didn't issue any variances at all about those, according to the city's website, which makes me think that this was built, and I'm still back to, when did the 1,000-foot rule come into play? And if it was in December, then the city definitely made a mistake in not enforcing its own laws. And then I find that the Supreme Court decision does appeal, because we didn't enforce our own laws, and that created a situation of this, because we do see other permits and things. On the other hand, if that 1,000-foot ordinance came into play in April, then of course you wouldn't receive, because you were granted occupancy in January, and so you wouldn't receive any notices that the city had changed its ordinance. That's why you have to pay attention to things in your local area, to my case at my home. And so it very much, and I am also very, very concerned that you've received building permits without, because this is a new facility, and that should have come before this board as a variance request. And the fact that it didn't very much concerns me, because some part of the city isn't doing its job. And that, that's a separate issue, but it goes to the case as terms of, sorry.
Commissioner Jones, a point of order, please.
Sure.
The permitted activity that has occurred to date has been for internal renovation work. It's not been for expansions.
It doesn't matter. That's not a limitation.
Point of order.
Okay, go ahead.
The record shows that these have been for internal expansions, and that was one of the items that was clearly noted, that these have been for internal expansions. It has not been to alter the size of the building or to add physical structures beyond itself. So we have to be very cautious about that statement and what has been permitted so far.
So the statement is, for use other than residential cannot be changed in area, height, bulk, or use. To the point of this new application, what he's doing is a change of use of that building. That building was, that area of the building before was never a medical use. And therefore, this would violate this section here as a change of use. And that's my consideration, is that again, what did the president know and when did he know it? And if the change was in April, then you were already occupying it and it was your obligation to know what the change in laws were. If that applied before then, before you received your certificate of occupancy, it seems to me that that then falls on the city, because at that point the city is not following its laws. And if they were going to grant it as a continuing, yes, you will grant you a non-conforming use, I think that should have been, I think that should have come before us as a zoning board to say, hey, this is a unique property because they're in the middle of construction, we just changed our laws, we need to give them a unique variance in this case. And in which case we probably would have. I mean, you're 99% done with your property and we just changed the laws on you. In which case you would have your variance, which obviously you didn't get because there's no record of it anywhere. So I'm back to, for me, the consideration, in reading the Supreme Court case, I do think that applies. If the 1,000-foot changed in April. And to the point, City Attorney, is there any way we can look up to see what exactly the changes were in April?
We can, if we want to take a recess. As I recall, they dealt with transitional housing and some other provisions of the code, but I can go pull that for you and bring that back if you want to take a recess.
If you would, please, sir.
I move we adjourn for recess for 10 minutes?
It'll take me probably that.
Okay.
So we're recessed here.
believe that it did not.
We do need a,
I don't think we necessarily have to call a vote. I think we can agree to a recess.
okay.
Yes. So we are in recess.
Right.
Applicants, parties coming back into the room, or we got everybody now?
We're still waiting on two.
Okay.
There it is, right there. This is the change to the ordinance.
All right, we are now out of, so,
It says it right there.
gentlemen, let's hold our conversations, please.
Yep.
All right, Attorney Marcel, if you will, please, you have the information that was requested.
Thank you, Commissioner Moreno. So I went and I pulled resolution number 100 that was heard by the Battle Creek City Commission on April 13th, 2021, which was a resolution adopting ordinance 04-2021 that amends the zoning code and zoning map for the city of Battle Creek. The history, background, and discussion section of that resolution, which was prepared by Eric Felt, the planning/zoning coordinator who preceded Ms. Cronander in her position, noted that the basis of these revisions were amendments to address various errors in the new zoning code and zoning map. And there were amendments to sections 1230, title, purpose, and scope, 1240, zoning districts and map, 1241, schedule of regulations, 1250, supplemental zoning district standards, 1251, standards applicable to specific uses, 1262, landscaping and screening, 1263, signs, and 1281, administrative procedures. Mr. Felt noted in his report that the additional land uses, specific uses were being added within the zoning code dealt with 1, transitional and supportive housing, and 2, small dental and medical clinics. The body of that then discusses those transitional and supportive housing and the amendments to various sections of the ordinance for those types of housing, including adult foster care and child care facility, state licensed residential facilities, transitional and supportive housing. The report also discusses the second edition recommended is dealing with small dental and medical clinics, primarily dealing with the size of those being, trying to define those in terms of square footage, either over or under 20,000 square feet in size. And so that was the general thrust of the April 13th, 2021 Resolution 100 that was approved at that time.
So if I heard you correctly, there was nothing in the amendment of April 13th that changed anything regarding our medical marijuana ordinance?
Correct.
Okay.
And Mr. Jones, this is not, my understanding, this was an application to the city for expanding a building, not a change of use. The use of this building preceding December 2020 was marijuana. The use has continued to be marijuana. The request was to increase the size of the building.
No, I understand that. So the change of use comes into play with the other half of the building, not this suite A, but suite B or C or whatever.
That's not before this body.
I understand that. What I'm saying is that
You're talking about the other tenant at 4661 Dickman?
yes,
My recollection is that they are on a similar timeline. Again, my recollection, that's not been an issue.
Sure.
They have not applied to the city for a variance in their dimensional size, nor have they applied to the city for any variance in terms of a change of use. So, in looking at
but we have granted them building permits.
there have been a lot of building permits. None have been for a variance. None have been for a change of use. That's a very specific request to this body.
So
Bill, if what is being proposed, if I think I'm hearing you correct, is either one way or another, the suggestion is that once an entity goes in, they never have to ask for another building permit.
no.
Please let me finish, Commissioner Jones. Or the alternative is that nothing can ever change. Neither of those is acceptable for either side of the equation. It's not fair to the municipality, and it's not fair to the property owners. That is why the ordinance contains what it does in terms of how to handle non-conforming uses and the process that they would go for if they're seeking to expand or change their use.
I understand that. And that really, none of that was my discussion.
Okay.
I mean, that's not what I'm saying at all.
Okay.
So two separate issues. We have this case and this case, and that applies to non-conforming and a change of all of that. We also have a potential case coming up because we have permits being issued that, I don't want to say they violate the law because I don't think that's the correct terminology, but they're issuing them permits to do something that we know is illegal.
I'm not aware of that, Mr. Jones.
So is Suite C, could they build a marijuana facility of any type in Suite C? The answer to that is no, because they are within 1,000 feet.
But they're already there as a medical.
No, Suite C is not.
Okay.
Suite C is a different property, it's a different owner, it just happens to share the same building.
And their next door neighbor has not been approved for a marijuana facility because they're within 1,000 feet.
Right, but what I'm saying is they are proceeding with construction in that area to that point. I mean, okay, I'm going to table that issue for Suite C because that really is secondary, but I will approach you afterwards.
Okay.
Because that is something that needs to be concerned for them as well as for us, okay?
Sure.
The property owner has a reasonable right to know if he can proceed with this project.
Right.
And that's, so as to this, I understand what it's saying. I understand that, that it falls into the category of non-conforming use. Because what you're telling me now is that the change wasn't made in April. So we didn't change the rules on you in the middle of the game, okay? Unfortunately, a very bad timing, you were granted occupancy without, the city should have enforced its laws about 1,000-foot setback. And for whatever reason, the city did not do that, okay? I don't know why. It never came for us before a variance. It never did that. For whatever reason, the city did not enforce its laws about your facility, Suite A. And for that reason, I find it was an error on both sides' part, relating to that Supreme Court decision that both sides made an error. In following the Supreme Court's decision, I'm going to move to grant you this because it is very clear that the city made an error. And at the same time, it is also all of our citizens' duties we should follow the law. I used to be a structural engineer. I had to pay attention to things that were being done, and it was not up to, the state to inform me that they were changing a law. It was up to me to know that they were changing the law to my profession, okay? And the same would apply to you. So I find that there was an error made on both sides, and I'm going to follow the Supreme Court decision, and I'm going to vote to grant you the change.
Thank you. Are there any other comments?
I have a question for the city attorney because I need
Please.
this cleared up. Because in this report from the Planning and Zoning Administrator, Susan here, it's under the summary, it reads, the zoning ordinance effective December 11th, 2020 amended April 13, 2021, states that the medical marijuana processing facility must be located at least 1,000 feet from properties as measured between nearest property lines containing any of the following issues, and it goes into residential. Based on the way you wrote that, when was the 1,000-foot setback clarified in April 13th?
No.
Was
No.
any part of that
Yes, city
made,
attorney just said.
any correction in the language made on April 13th on that amendment?
Evidently not according to the resolution that he just read.
Okay, that's what I wanted to clarify, because I was hearing what he was reading, and then I was seeing this, and it was a little confusing there.
I see.
Okay,
sorry.
but it definitely was in effect in December 2020. The 1,000-foot setback was in the language.
It must have been because it wasn't amended after that, right? In that, for marijuana. And if I may, for the board,
Please.
make a statement. And in regards to whether or not the city may have made an error somewhere along the way, that could possibly be, I don't know. But what is before you now is an interpretation of the ordinance the way it stands, which is with the 1,000-foot buffer, nonconformities, not allowing a change in height, bulk, or area. And
Point of order.
the question before you is the
Let her finish.
appeal, and is it, do you want to continue? Let's presume it is an error.
Point of order.
Can't say. But
Commissioner Jones, please let her finish.
Point of order.
Sir, she is trying to complete her point.
To which a point of order stands in.
There is
Yeah.
a point of order.
Yes, there is, because she is making testimony. She is making.
Commissioner Jones, please.
To our parliamentarian, would a point of order be in order?
A point of order may be in order. Commissioner Jones, a point of order may be appropriate. Commissioner Moreno asked that Susan Cronander be allowed to finish. Commissioner Moreno, Mr. Jones is not wanting to allow Susan Cronander to finish so that he may express his point of order.
It would be the chair's decision.
Indeed, and that's why I'm disagreeing with Commissioner Jones.
It's your decision, sir.
And I have ruled. Please continue with your statement.
so what is before the board is, do you continue the error then, if presuming it is one, and make it larger? Or do you say, look at the zoning ordinance and stop it at this point?
Thank you.
Thank you.
To my statement of the point of order, it is our rule that during commissioners' discussion, that it is the commissioners' discussion, and that neither the appellant nor anybody in the public nor anybody else, including city staff, may make argument during the commissioner's statements. It is the commissioner's time to deliberate. If we had asked her a question, she could respond. But we did not ask her a question. She made argument not during her time. And that is not allowed.
So Commissioner Jones, as a chair, I can exercise the fact that she wanted to make a comment as staff, and she was making a comment. And that's strictly what she did. It was a comment. She wasn't giving us guidance to do or not to do, merely making a comment on the matter at hand and the matter of discussion. On that note,
So to the city,
unless there's something more substantive that we need to discuss, we need to move on.
it pertains to our rules of order.
That is part of our rules of
It-
order.
it
Staff is
pertain-
allowed to comment in our discussion should there be a need for clarification or just informational sharing. That's all that she did.
To our city attorney, would a judge allow a prosecuting attorney to interrupt a defensive attorney, or would allow either attorney to speak when it was not their time to speak?
There is a process in the Michigan court rules for an objection to be made, so the manner of speaking would be, in terms of making that objection, either as to an inappropriate question or a type of response or some point that would need to be made. So yes, a judge would allow an interruption. I think.
But it wouldn't be an argument.
It wouldn't necessarily be an argument, no.
To the
That would
city
be,
attorney, are we bound by the rules of court procedure?
no, we're not.
Thank you. On that note, if there's no further substantive discussion from the board, I'm calling the question.
Mr. Moreno, I have one other question. I was waiting for him to settle. I just
Please.
want clarity on a particular point.
Yes.
The application for acting under the presumption, and I'm not saying it is, but let's presume for a moment that they applied and they were allowed to proceed with the renovations interior in this building. Was that renovations inclusive of this new addition at that time? Or was the new addition something they applied for after the fact, and this was a separate building permit we're talking about?
Mr. Delaware, the present request to expand the size of the building,
Yep.
it was a separate request. It was May of this year that followed in time without any knowledge to the city beforehand of a desire to make that expansion to the building.
Perfect, that's what I needed to know. Thank you, sir.
All right. If you will please, as a note, the motion stands to approve the reversal of the administrator's decision. So a vote of yes means that you will be reversing the administrator's decision. A vote of no upholds the administrator's decision. All right? Crystal, if you will please, the vote.
Board Member Delaware?
No.
Board Member Hanner?
No.
Board Member Jones?
Yes.
Board Member Moreno?
No, and I'm upholding the administrator's decision because of the fact that this item was clearly noted early on in the process, and unfortunately, the applicant did not take sufficient note of it, and to that end, that is why I'm going to uphold the administrator's decision.
And Board Member Rogers?
No.
All right, gentlemen, we are upholding the administrator's decision. Of course, that does not stop you from pursuing this further legally if you so choose.
We'd like to leave these for the record.
You certainly may.
Thank you.
Thank you. All right, then. Moving on here, we have our minutes from our last meeting. Has everybody had a chance to review them? Are there any corrections or any additions we need to note to them?
No.
If there are none, I'll entertain a motion for approval of the minutes.
I move that the minutes be approved as written.
Is there
Support.
All right, moved and support. All in favor?
Aye.
Opposed? All right.
I'm just going to abstain.
Can I just ask who was first and who was second? I'm sorry.
Mr. Hanner was.
I was second, he was first.
Okay, thank you.
All right. All right. Comments from the public?
It's not a voice vote.
Are there anybody here in the public sphere that wants to have public comment here? All right, then, let's move on. Comments from the members. I want to thank staff for the time and the effort put into this. This is a very grueling conversation we just entertained, but it is one of those matters that this board exists for. So thanking staff, thanking the commissioners for having done your parts as we should. Are there any other commissioner comments?
Not today.
All right then. Unless there's an objection, we can stand adjourned.
Thank you. Thank everybody for their service.
Thank you, everybody.